The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, July 1st, 2021. If you enjoy this podcast, you should check out our newsletter, an often irreverent take on recent Court of Appeals opinions, which we publish every Friday. You can subscribe at shortcircuit.org or find it on the Volokh Conspiracy blog. And please also check out our sister podcast, the documentary series Bound by Oath, and our latest two-part episode, The Shooting of Bobby Moore. We haven't talked about qualified immunity on Short Circuit in a very long time. We've left that to our experts over on Bound by Oath. But this week, it's back. And where else would we look at qualified immunity than the crucible of QI, the Fifth Circuit? The Federal Court of Appeals for Texas, Louisiana, and Mississippi somehow supplies more than its fair share of outrageous decisions and terrible facts. We're going to focus on two QI opinions from the Fifth Circuit this week, and also discuss a spirited denial of en banc, and also what's been going on at the Supreme Court to cause some of these ripple effects in the lower courts of appeals. And to help us walk through some of these facts from the last few days, we have a special guest who was an attorney in one of these cases. His name is Nicolas Riley. He is currently, but not much longer, senior counsel at the Institute for Constitutional Advocacy and Protection at Georgetown Law, and soon he's going to be moving over to the Justice Department. Although he's moving on to bigger and better things very soon, he's been very gracious to allow some time for us on Short Circuit. So, Nick, welcome to the podcast.
Thanks so much for having me.
Also joining us is IJ attorney Anya Bidwell, co-producer of Bound by Oath and slayer of governmental immunities. Anya, thanks for coming back.
Thank you for having me, Anthony.
Nick, so you were counsel on this case, J.W. versus Paley, which the Fifth Circuit ruled on last week. If you could tell our listeners a bit about what happened to your clients and then what the court said at the appellate level.
Sure. So the JW case is an excessive force case arising out of an incident that happened at a Texas high school back in the fall of 2016. Javon, and I'll call him Javon, was the student and the plaintiff in this case because he's now in his early 20s. At the time, was a 17-year-old high schooler at a school just outside of Houston, a special needs student, having a tough day. He was being made fun of, which was unfortunately not uncommon in his routine at school, and got into an argument with the student who was mocking him, had an outburst, and then stormed off out of the classroom. And he was going to what he referred to as his chill-out classroom, which was a room that he would sometimes go to cool off when he had moments like this. And he knew that this was a good way for him to sort of calm his nerves. But unfortunately that day, there was another student in the chill out room. And so he didn't feel like he could stay there and, kind of keep storming off down the hallway towards the exit of the building. And that's where things really kind of went off the rails. He's trying to leave the building, wants to get some air to cool off. And there are school administrators that meet him there. There's a teacher, and there are a couple of school resource officers, school police officers, who essentially surround him and try and stop him from leaving the building. He engages very briefly in conversation with some of the administrators and officers. Again, keeps trying to kind of insist that he needs to go outside and get some air. And when he attempts to do that, they physically begin restraining him. One of the officers puts him briefly in a chokehold. He keeps, he's having a hard time struggling at that point, getting out of the chokehold, and the officer then tases him for quite a long period of time, about 20 seconds. He continues tasing him even after Javon kind of falls to his knees and is, lying prone on the ground. The officer continues tasing him at that point for another 10 seconds. So about 20 seconds in total, 10 of which he's on the ground. It's obviously tremendously painful for him. He loses control over, his bowels and, urinates on himself. It's really, has this kind of really traumatic impact on him, causes him to miss a fair bit of school after the incident. and ultimately leads him and his mother to file suit against the officer and the school district. And they bring a handful of claims, some federal statutory claims under disability rights law, some claims under the Texas Constitution, and then most importantly for the purposes of what we're talking about, he brings a couple of federal constitutional claims, and in particular he brings a Fourth Amendment excessive force claim against the officer, and he also brings a 14th Amendment substantive due process claim, essentially arguing that this was a form of corporal punishment, right? And it shocks the conscience. The district court grants summary judgment ultimately to the school district and the officer on all claims except for the Fourth Amendment excessive force claim. The officer had moved for summary judgment on the basis of qualified immunity on that claim, and the district court said, in our view correctly, that there are all these factual disputes surrounding this incident. There is body cam footage, but it's shaky and choppy and cuts out at times. There's disputes about how much, if at all, Javon was resisting the officer. These are the kinds of factual disputes we need to go to trial on. We're not going to resolve that here at summary judgment, and I can't determine whether this officer is entitled to qualified immunity without a resolution of those factual disputes. So again, qualified immunity denied at that stage. Officer appeals interlocutorily to the Fifth Circuit, and that's where my office got involved in helping to represent Javon in the Fifth Circuit in defending the district court's judgment. The Fifth Circuit ultimately reversed last week, as Anthony alluded to at the top, and their reasoning was that the state of the law in the Fifth Circuit on whether or not the Fourth Amendment even applies to seizures conducted by school officials is uncertain. And therefore, because the state of the law in the Fifth Circuit is uncertain, there's no clearly established law that would have fairly put this officer on notice of that his conduct was violating the Constitution, and therefore he gets qualified immunity. And that's where we are now.
So what do you think about the clearly established analysis here? It seems like they're using this one case. It is an unpublished one that goes against the consensus of cases on the Fourth Amendment violation here. Do you think the clearly established reasoning was too narrow, or is it just consistent with kind of the general case law on corporal punishment in the Fifth Circuit?
Right. It's a great question. So, the case you're alluding to is this 2004 unpublished decision, Flores, where the court had, in Flores, basically said, we're not sure that the Fourth Amendment should apply to seizures by school officials. What gives me pause about Flores and what I think is so disappointing about the decision last week is that there's a more recent published decision called Curran v. Alshire, in which the Fifth Circuit held that a school resource officer did violate clearly established Fourth Amendment law by, in that case, slamming a student into a wall. And I think what's important about that Curran case is that it's not simply holding that, a school resource officer could violate the Fourth Amendment under certain circumstances. It's holding that the law on that is clearly established, right? So it's really, I think, removing any doubt about the application of the Fourth Amendment, that objective reasonableness standard, what lawyers call the Graham standard. The application of that standard to school officials really is settled law after Curran, which was decided in 2015, a year before the incident that gave rise to our case.
It seems like there is a little bit of kind of this strange thing going on with like the 14th Amendment and corporal punishment in the Fifth Circuit versus Fourth Amendment excessive force claims. And like the court is kind of continuously kind of hearkening back to essentially there's no such thing as a due process violation. So maybe we should be skeptical about Fourth Amendment claims too. Do you think it's part of like what they are so hesitant about?
I do, and I think the way you described it is exactly right. And just for context for listeners, what Anya's alluding to is the Fifth Circuit's rule, and it is an outlier rule. The Fifth Circuit's the only circuit that approaches substantive due process claims based on corporal punishment in this way. The rule is essentially that you can't bring them in the Fifth Circuit because under the Fifth Circuit's lens of analysis, as long as there is some other mechanism of challenging corporal punishment in schools, including as long as there's a criminal law on the books prohibiting it, you can't bring a civil suit under the substantive due process line of theory of constitutional liability because of that existing alternative remedies. Again, that's very different from what other circuits do. Most circuits apply something like a shocks the conscience standard when they see corporal punishment committed by school officials. The Fifth Circuit's taken a different approach, and I think what Anya's exactly right about is that has sort of driven, in some ways, their approach to these Fourth Amendment claims. The Fourth Amendment, obviously, is a different provision of the Constitution. It protects different interests. It shouldn't really matter, whether the Fifth Circuit's rule on corporal punishment is right or wrong. It shouldn't really matter. The unavailability of a remedy under the substantive due process theory shouldn't preclude liability under a Fourth Amendment theory. And I do think that there is a little bit of kind of conflating those two things, as Anya suggested.
Nick, one thing that really confused me about the opinion, there's only 7-page opinion, is that usually when we read these qualified immunity cases, even the ones that really seem to be pretty aggressive, is that it's because of the specific facts of this case don't line up with an earlier case that qualified immunity applies. Here it seems that qualified immunity applies because you just can't have a Fourth Amendment claim in the context of there's no clearly established right that you can have a Fourth Amendment claim in the context of a school officer as opposed to other kinds of officers, which seems to be bringing it to a whole nother level because, as you said, there is this case that says that it does apply in the school, and the whole claim is an unreasonable seizure, and no one's disputing that this was a seizure, and the question of whether it's reasonable or not has been adjudicated in schools before. So I'm confused. I can't say, to tell you the truth, whether that's a worse or a better analysis than the ones we usually disagree with, where there's just a very slight change of facts from one scenario and another, and therefore qualified immunity doesn't apply. But it seems to be just a different way of applying qualified immunity that doesn't have a lot of precedent for it.
I think that's exactly right. I mean, the way I think about it, this is, along the lines of what you're describing, Anthony, is that, we think of qualified immunity in the typical case as being a comparison of facts in one case to facts in another case, right? What's happening here is really applying that qualified immunity lens, that sort of deference to the officer, at really a threshold stage, which is even before you get to the fact-to-fact comparison, there's just this question about, well, what is the legal standard that even applies here? And if there's any uncertainty on that threshold legal question, then we're going to apply qualified immunity before you even get into that, the usual analysis of is this situation factually analogous to a prior case? It's not even a facts-to-facts comparison. It's really kind of this doctrinal analysis that happens on the front end, which is getting the qualified immunity treatment. So I think you're right. This does seem a little different from what you often see in qualified immunity cases.
And I want to bring the listeners' attention to this corporal punishment law and the 14th Amendment jurisprudence, right, that is taking place in the Fifth Circuit. As Nick mentioned, it's very much of an outlier, and it's kind of crazy. Just a couple of weeks ago, there was a similar case, TO versus Fort Bend Independent School District, right? And in fact, this opinion cites to that case, and it's a 14th Amendment due process violation, and they basically say, you can't sue a school employee or an officer in a corporal punishment context under the 14th Amendment. And the TO case is also outrageous, right? In terms of facts, the kid was like a first grader, and this teacher basically slammed him to the ground and chokeholded him, right? And you can't, she wasn't disciplined. She's still working there, and you can't bring a lawsuit against her. Judge Willet wrote both a majority opinion saying that, we can't do it in the Fifth Circuit. Unfortunately, you don't have a claim. And also wrote a concurrence specifically asking the Fifth Circuit to re-examine this jurisprudence. Nick, what do you think about this what is the Fifth Circuit driven by? Why are they doing it this way?
Yeah, no, it's a great question. We saw the TO case. I actually learned about it from the IJ Short Circuit newsletter, of which I'm a big fan and a longtime reader. Obviously, it's very disappointing. It's obviously a very disappointing result for all the reasons you mentioned. I think one of the things that you see with, and I think Judge Wiener's concurrence, as you noted, does a good job of kind of walking through this, is that this is really an old rule in the Fifth Circuit. And, it hasn't held up well over time. I think you've seen other circuits, consider what the Fifth Circuit's doing and choose to go a different route. This has been an issue for Judge Wiener. He wrote a similar concurrence in a case about 20 years ago. And in his most recent concurrence, he sort of says, the law in other circuits has not been following us. We've been kind of becoming even more of an outlier on this particular issue. So it's really disconcerting, particularly when you see it applied in situations like the TO case that you described.
Well, turning to another Fifth Circuit case, Anya, I understand that the court actually ruled against the government in a qualified immunity case last week. Tell us a bit about Kelson versus Clark.
Absolutely. This is a heartbreaking case. The Fifth Circuit, as you mentioned, did the right thing. It came through. It affirmed the denial of qualified immunity to these paramedics who refused to treat a homeless man who had visible injuries and who asked them for help. This man, Herschel Fletcher, right after Christmas in 2016, he was assaulted outside of the soup kitchen, and then again in a separate incident when he was punched in the head, fell and hit his head on a wall. Bystanders saw that. They called for help. Police and these paramedics arrived. Fletcher then told the paramedics that he needed medical attention, but instead of giving it to him, they stood on the sidewalk and they laughed. You can actually see that in the video with Mr. Fletcher sitting on a sidewalk, helpless, and 2 paramedics and 3 officers harassing him and openly laughing. The officers then brought Mr. Fletcher to jail. From what I understand, that's actually because he didn't have a home, so that was a place for them to actually have him spend the night. And he died there the following morning from his head injuries. The 2 paramedics then falsely stated in their reports that they never had contact with Mr. Fletcher. And because of this, they were later indicted for falsifying government reports. And they also pled guilty to that. The estate of Mr. Fletcher sued the paramedics and the officers, and then paramedics filed a motion to dismiss, which the officers didn't do, by the way. Paramedics filed motion to dismiss and invoked qualified immunity. The district court denied qualified immunity, and the paramedics went up on interlocutory review. Listeners to this podcast, hi, Will Langley, by the way, I know you're a listener. Listeners to this podcast would know that this interlocutory review procedure is actually one of the worst things about qualified immunity doctrine as it works today, because this procedure can potentially delay litigation for years, right? So that's what happened here when the paramedics basically stopped all the litigation in its tracks below and went to the Fifth Circuit and said, hey, we know we lost on this intermediary doctrine thing, but you don't have to wait for final judgment. You can review that decision right now, and hopefully you can tell the district court that they were wrong. Well, the Fifth Circuit didn't tell the district court that they were wrong. Judge Higginson, writing for the unanimous court, denied qualified immunity to the paramedics, holding that at least at the motion to dismiss stage, plaintiffs showed a violation of a 14th Amendment right when these paramedics failed to treat him and his visible head wounds. And these head wounds ultimately led to his death. So that was pretty fascinating, right? They also said, Judge Higginson and Judge Elrod, and who was the third judge here?
Weiner.
Judge Winner, there you go. The 3 of them basically said that not only was there a constitutional right, but that right was clearly established, right? And they kind of looked at it rather broadly. They said that there is this right to pretrial detainees that they have a 14th Amendment right to a medical care. And then this right was violated and it was clearly established, right? This is a very interesting case, especially in light of Taylor versus Riojas and McCoy versus Alamo, right? You folks who listen to us regularly would know that those two cases were, prison conditions cases where the Fifth Circuit affirmed qualified immunity. And then the Supreme Court, when it looked at Taylor versus McCoy, the Supreme Court said, actually, you're applying the clearly established test way too narrowly. So you're actually wrong. We're going to reverse and we're going to vacate your decision. So the Fifth Circuit got slapped on this twice this term. And it seems to be at least somewhat paying attention to these decisions. And when I was reading Kelson versus Clark, I kind of thought back to Taylor and to McCoy and thought maybe something was going on there. And, judges are definitely paying attention to what the Fifth Circuit is having to say, and they are trying to dial back on, looking at the clearly established test, as something that requires very fact-by-fact specific analysis. Because like in Taylor, for example, right, the detainee was there in these horrible feces-filled cells for 6 days, and the Fifth Circuit basically said, well, we don't have a case law that talks about 6 days, right? And the U.S. Supreme Court basically said, this is not how you should be looking at this, right? This kind of behavior by government officials, quote, offends the Constitution, right? And they should have been on notice that it offends the Constitution. And there is no need to look at exactly how many days this poor fella was in these freezing feces-filled cells. So maybe Kelson versus Clark, is kind of an indication that the Fifth Circuit is listening.
Nick, what are your thoughts about these tea leaves that the Supreme Court has been sending recently? The McCoy case being one that, although the QI law hasn't really changed because of that, they're taking a second look, especially it seems in maybe in some cases in the Fifth Circuit.
Yeah, I mean, I think it's a promising development. It used to be that the only times you'd get a GVR from the Supreme Court in a qualified immunity case, it was in favor of the government. It was in favor of the officer. And so I think, seeing the Taylor case, the Alamo case, I think is at least a step in the right direction towards some balance. It's obviously, as you both alluded to, it's very difficult to kind of read the tea leaves as to exactly what this portends for the future. But I was at least gratified to see both those cases. And I would just, flag, I think both of those cases were really brought by Rights Behind Bars, a new organization that was involved in both the petitions in both of those cases. So it is, I think, part of what we're seeing, I think, more advocates in the public interest world paying attention to qualified immunity. And you hope that translates into something at the actual decisional level too.
And that makes me think about just public interest and qualified immunity and lawyers in general, right? Because it's actually extremely hard to find lawyers to represent civil rights plaintiffs because qualified immunity is such a difficult doctrine to overcome. And you might be, in litigation for years before you can even see trial, right? Even when your claims are really good, well-pleaded claims. So yes, public interest organizations like Rights Behind Bars, like MacArthur Justice Center, who was the other, law firm who brought the McCoy case. They were co-lawyering it, right? It's really important to see those guys step up and represent plaintiffs in qualified immunity claims. But it's also important to make sure that qualified immunity is not such a huge barrier that no lawyer is willing to represent a civil rights plaintiff, even with legitimate claims.
Anya, I mentioned tea leaves a moment ago. Tell us about this other case that mentioned a telegraph signal.
Yes, Judge Willet was all about the telegraph signal, and so was Judge Jolly, apparently. But the case is Ramirez versus Guadarrama, right? And it was there was a first Fifth Circuit panel decision where they said that the officers who set this man on fire were entitled to qualified immunity. And then there was a petition for en banc review. And what we're talking about is essentially concurrences in support of the denial of en banc review and then dissents from the denial of en banc review. And it's really fascinating because you have 3 separate concurrences, and you have 2 separate dissents. One dissent specifically on qualified immunity by Judge Willet. Another one is by Judge Smith on a separate issue. And then you have 3 concurrences disagreeing with Judge Willet on qualified immunity. And the facts of the case are fascinating, right? You again have this kind of mentally unstable man. He, covered himself with gasoline and he was threatening to light himself on fire. But the room where he was standing was also covered in gasoline, and there was his wife in there and there was his child in there, and the officers came on the scene, right? But they knew that if you use tasers, right, then that would ignite a person who is covered in gasoline. They knew that. And they still chose to go ahead and use the taser on this man. So then he was put on fire. And so Judge Willet's dissent from the denial of en banc review is essentially that. He basically says they knew that if they were to do this, that would have set him on fire. And they continued with that, right? There could have been other options. And the concurrences from the denial of review are all about, no, you don't know there were other options. And the officers acted absolutely reasonable. This is a scary situation. This is a split-second type of situation, right? And what's also interesting is that they all talk about Taylor and they all talk about McCoy, and they agree that those 2 decisions are very important and that the Supreme Court is indeed, maybe strengthening Hope versus Pelzer, the one important post-Harlow qualified immunity case where the Supreme Court basically says that fair warning means that sometimes when a violation is obvious, you don't need a specific case on point. You should have known it nonetheless. So judges in the Fifth Circuit agree that those 2 are important, that the Supreme Court is sending them a signal, right? But they disagree that in this particular case, whether qualified immunity should shield those officers or not. And it's kind of, unusual to see so many concurrences and dissents about this one case, right? It's kind of a little bit of, showing the inside workings of the Fifth Circuit, and also kind of, they're testy. Some of those concurrences are testy, right? Like Judge Jolly, he's obviously irritated with Judge Willet, and he, makes fun of the Morse telegram that Judge Willet opens with, right? So it's kind of it's an unusual case in that sense too, where you see kind of maybe you see more than what you want to see in terms of disagreements between judges, where it actually gets personal.
And the line I think that most stands out is Judge Ho's concurrence. As judges, we apply our written constitution, not a woke constitution.
And so I don't understand.
Judge Willet's dissent may be many things. I don't see it really as woke.
I don't see it as woke at all, and I also don't understand why Jolie, Oldham, and Ho all needed to write separate concurrences, essentially telling Willet that they disagree with him, right? I think one would have been enough. I can totally see that. But why do you need 3 separate and all trying to take shots at him? That's just beyond me. I think that went way too personal.
One point Anya, I'd like to ask you a question before we wrap up on the opinion. Is one point I didn't really get that Judge Willet was discussing was, all of the concurrences are saying, what else should this cop have done instead of firing the taser? What else could he have done? And Judge Willet says there's other options and we need discovery to figure out what they are. And I think, and it seemed like the concurrences weren't happy with that because they're saying, look, what is the other option? And then the answer is, well, whatever they are, we'll find out in discovery. It seems to me he would have been better served not to rely on discovery as like the antidote to that, but on the fact finding, right? So how the system is supposed to work is you go to a fact finder, whether it's a jury or a bench trial with a judge, and you figure out what really happened and what else could have happened. And maybe you get testimony from other officers, like what would you have done in that situation? Instead of saying, well, we'll find it in discovery, whereas because this is a very well pleaded complaint, it seems from the opinions, discovery would just have tried to back that up. So I think that might have been a little, my opinion is I think that might have been a little off to rely on discovery and not say what else would have happened. Like when I read this, what else should have happened was anything else. Because
that's right.
If you're trying to stop someone from burning the house down and you tase them, which creates the burning. In fact, I'm sure it's more than this guy waving around a lighter, and who knows if it would have actually caught fire or not. I don't know. You try to talk the guy down as much as you can because once he drops the lighter, it's the same thing as tasing him. You try to tackle him. You try whatever it is. It's going to be better than the tasing. That's the ultimate issue, and yet it seems like, well, discovery, might figure out what else we should have done. It seems to me it should go to a fact finder is the bottom line. But what's your read on that?
I agree. I think one of the worst excesses of qualified immunity, right, is that it prevents fact-finding from ever taking place. And that's, horrible. And I think Willet kind of gets at it. Maybe he is not saying it directly, but at the end of the day, that's what really bothers him, right? He basically says, how in the world can you guys do this at the motion to dismiss stage? Just throw it out and not even worry about it. And that's kind of what qualified immunity does, right? If there is an excuse whatsoever to say that somehow the law is not clearly established and you have a lot of, latitude in how you want to apply the clearly established test, including by applying it in a fact-by-fact analysis, then you throw out a well-pleaded complaint, right? And a constitution is nothing but an empty promise. So at the end of the day, I think Judge Willet is concerned very much with that. We are at the motion to dismiss stage. How in the world is this possible? It can't be he is pleading with the Supreme Court, essentially, to take this on and do something about it. And I absolutely agree with him. At the motion to dismiss stage, this should not happen.
Well, we're still waiting on the Supreme Court to do something about qualified immunity beyond these tea leaves and telegraph signals that they've been sending. But we hope that may change in the near future, and there are signs perhaps that may change in Congress in the near future. So we're watching both developments. While those happen, we're very happy that our friend Nick will be going to bigger and better things. But we want to thank him so much for coming on the show today, Nick. It's been a pleasure to have you.
Same here. This was a lot of fun. I appreciate it.
It's great to have guys like Nick at the DOJ.
And we will affirm that. And thanks so much to Anya for coming on as always. And to the rest of you, I'm going to say, please have a very happy 4th of July. And in the meantime, to get engaged.